Hello friends, welcome to my channel Jury. Today we are going to discuss chapter 5th of CRPC named Arrest of Persons. Section 41. When police may arrest without warrant. First, any police officer may, without an order from a magistrate and without a warrant, arrest any person A. who commits in the presence of a police officer a cognizable offence, B. against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offence punishable with imprisonment for a term which may be less than 7 years or which may extend to 7 years, whether with or without fine, if the following conditions are satisfied, namely, first, the police officer has reason to believe on the basis of such complaint, information, or suspicion that such person has committed the said offence. Second, the police officer is satisfied that such arrest is necessary A. to prevent such person from committing any further offence, or B. for proper investigation of the offence, or C. to prevent such person from causing the evidence of the offence to disappear or tampering with such evidence in any manner, or D. to prevent such person from making any inducement, threat, or promise to any person acquainted with the facts of the case so as to dissuade him from disclosing such facts to the court or to the police officer, or E. as unless such person is arrested, his presence in the court whenever required cannot be ensured, and the police officer shall record while making such arrest his reasons in writing, provided that a police officer shall in all cases where the arrest of a person is not required under the provisions of this subsection record the reasons in writing for not making the arrest. B.A. against whom credible information has been received that he has committed a cognizable offence punishable with imprisonment for a term which may extend to more than 7 years, whether with or without fine, or with death sentence, and the police officer has reason to believe on the basis of that information that such person has committed the said offence. C. who has been proclaimed as an offender either under this code or by order of the state government, or D. in whose possession anything is found which may reasonably be suspected to be stolen property and who may reasonably be suspected of having committed an offence with reference to such thing, or E. who obstructs a police officer while in the execution of his duty, or who has escaped or attempts to escape from lawful custody, or F. who is reasonably suspected of being a deserter from any of the armed forces of the Union, or G. who has been concerned in or against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists of his having been concerned in any act committed at any place out of India, which, if committed in India, would have been punishable as an offence, and for which he is under any law relating to extradition or otherwise liable to be apprehended or detained in custody in India, or H. who being a released convict commits a breach of any rule made under subsection 5 of section 356, or I. for whose arrest any requisition, whether written or oral, has been received from another police officer, provided that the requisition specifies the person to be arrested and the offence or the other cause for which the arrest is to be made, and it appears therefrom that the person might lawfully be arrested without a warrant by the officer who issued the requisition. Section 41A. Notice of appearance before police officer. First, the police officer shall, in all cases where the arrest of a person is not required under the provisions of subsection 1 of section 41, issue a notice directing the person against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offense to appear before him or at such other place as may be specified in the notice. Second, where such a notice is issued to any person, it shall be the duty of that person to comply with the terms of the notice. Third, where such person complies and continues to comply with the notice, he shall not be arrested in respect of the offense referred to in the notice unless, for reasons to be recorded, the police officer is of the opinion that he ought to be arrested. 4. Where such person at any time fails to comply with the terms of the notice or is unwilling to identify himself, the police officer may, subject to such orders as may be have been passed by a competent court in this behalf, arrest him for the offense mentioned in the notice. Section 41B. Procedure of arrest and duties of officer making arrest. Every police officer while making an arrest shall a. bear an accurate, visible and clear identification of his name which will facilitate easy identification. B. Prepare a memorandum of arrest which shall be first attested by at least one witness who is a member of a family of the person arrested or a respectable member of the locality where the arrest is made. Second, countersigned by a person arrested. And C. Inform the person arrested, unless the memorandum is attested by a member of his family, that he has a right to have a relative or a friend named by him to be informed of his arrest. Section 41C. Control room at districts. First, the state government shall establish a police control room A. in every district and B. at state level. Second, the state government shall cause to be displayed on the notice board kept outside the control rooms at every district the names and the addresses of the persons arrested and the name and designation of the police officers who made the arrests. Third, the control room at the police headquarters at the state level shall collect from time to time details about the persons arrested, nature of the offense with which they are charged and maintain a database for the information of the general public. Section 41D. Right of arrested person to meet an advocate of his choice during interrogation. When any person is arrested and interrogated by the police, he shall be entitled to meet an advocate of his choice during interrogation, though not throughout interrogation. Section 42. Arrest on the refusal to give name and residence. First, when any person who, in the presence of a police officer, has committed or has been accused of committing a non-cognizable offense, refuses on demand of such officer to give his name and residence or gives a name or residence which such officer has reason to believe to be false, he may be arrested by such officer in order that his name or residence may be ascertained. Second, when the true name and residence of such a person have been ascertained, he shall be released on his executive bond with or without sureties to appear before a magistrate if so required, provided that if such person is not resident in India, the bond shall be secured by a surety or sureties resident in India. Third, should the true name and residence of such person not be ascertained within 24 hours from the time of arrest, or should he fail to execute the bond, or if so required to furnish sufficient sureties, he shall forthwith be forwarded to the nearest magistrate having jurisdiction. Section 43. Arrest by private person and procedure on such arrest. First, any private person may arrest or cause to be arrested any person who in his presence commits a non-bailable and cognizable offence, or any proclaimed offender, and without unnecessary delay shall make over or cause to be made over any person so arrested to a police officer, or in the absence of a police officer take such person or cause him to be taken in custody to the nearest police station. Second, if there is reason to believe that such person comes under the provisions of section 41, a police officer shall re-arrest him. Third, if there is reason to believe that he has committed a non-cognizable offence and he refuses on the demand of police officer to give his name and residence, or gives a name or residence which such officer has reason to believe to be false, he shall be dealt with under the provisions of section 42. But if there is no sufficient reason to believe that he has committed any offence, he shall be at once released. Section 44. Arrest by magistrate. First, when any offence is committed in the presence of a magistrate, whether executive or judicial, within his local jurisdiction, he may himself arrest or order any person to arrest the offender, and may thereupon, subject to the provisions herein contained as to bail, commit the offender to custody. Second, any magistrate, whether executive or judicial, may at any time arrest or direct the arrest in his presence within his local jurisdiction of any person for whose arrest he is competent at the time and in the circumstances to issue a warrant. Section 45. Protection of members of the armed forces from arrest. First, notwithstanding anything contained in sections 41 to 44, both inclusive, no member of the armed forces of the Union shall be arrested for anything done or purported to be done by him in the discharge of his official duties, except after obtaining the consent of the central government. Second, the state government may by notification direct that the provisions of subsection 1 shall apply to such class or category of the members of the force charged with the maintenance of public order as may be specified therein, wherever they may be serving, and thereupon the provisions of that subsection shall apply as if for the expression central government occurring therein the expression state government were substituted. Section 46. Arrest how made. First, in making an arrest, the police officer or other person making the same shall actually touch or confine the body of the person to be arrested unless there be a submission to the custody by word or action, provided that where a woman is to be arrested, unless the circumstances indicate to the contrary, her submission to custody on an oral intimation of arrest shall be presumed, and unless the circumstances otherwise require, or unless the police officer is a female, the police officer shall not touch the person of the woman for making her arrest. Second, if such person forcibly resists the endeavor to arrest him or attempts to evade the arrest, such police officer or other person may use all means necessary to effect the arrest. Third, nothing in this section gives a right to cause the death of person who is not accused of an offence punishable with death or with imprisonment for life. Fourth, save in exceptional circumstances, no woman shall be arrested after sunset and before sunrise, and where such exceptional circumstances exist, the woman police officer shall, by making a written report, obtain the prior permission of the judicial magistrate of the first class within whose local jurisdiction the offence is committed or the arrest is to be made. Section 47. Search of a place entered by person sought to be arrested. First, if any person acting under a warrant of arrest or any police officer having authority to arrest has reason to believe that the person to be arrested has entered into or is within any place, any person residing in or being in charge of such place shall, on demand of such person acting as aforesaid, or such police officer, allow him free ingress thereto and afford all reasonable facilities for a search therein. Second, if ingress to such place cannot be obtained under subsection 1, it shall be lawful in any case for a person acting under a warrant and in any case in which a warrant may be issued but cannot be obtained without affording the person to be arrested an opportunity of escape, for a police officer to enter such place and search therein, and in order to effect an entrance into such place, to break open any outer or inner door or window of any house or place, whether that of the person to be arrested or of any other person, if after notification of his authority and purpose and demand of admittance duly made, he cannot otherwise obtain admittance, provided that if any such place is an apartment in the actual occupancy of a female, not being the person to be arrested, who according to custom does not appear in public, such person or police officer shall, before entering such apartment, give notice to such female that she is at liberty to withdraw, and shall afford her every reasonable facility for withdrawing, and may then break open the apartment and enter it. Third, any police officer or other person authorized to make an arrest may break open any outer or inner door or window of any house or place in order to liberate himself or any other person who, having lawfully entered for the purpose of making an arrest, is detained therein. Section 48. Pursuit of offenders into other jurisdiction. A police officer may, for the purpose of arresting without warrant any person whom he is authorized to arrest, pursue such person into any place in India. Section 49. No unnecessary restraint. The person arrested shall not be subjected to more restraint than is necessary to prevent his escape. Section 50. Person arrested to be informed of grounds of arrest and of right to bail. First, every police officer or other person arresting any person without warrant shall forthwith communicate to him full particulars of the offence for which he is arrested or other grounds for such arrest. Second, where a police arrestor arrests without warrant any person other than a person accused of a non-bailable offence, he shall inform the person arrested that he is entitled to be released on bail and that he may arrange for sureties on his behalf. Section 50A. Obligation of person making arrest to inform about the arrest etc. to a nominated person. First, every police officer or other person making any arrest under this code shall forthwith give the information regarding such arrest and place where the arrested person is being held to any of his friends, relatives, or such other persons as may be disclosed or nominated by the arrested person for the purpose of giving such information. Second, the police officer shall inform the arrested person of his rights under subsection 1 as soon as he is brought to the police station. Third, an entry of the fact as to who has been informed of the arrest of such person shall be made in a book to be kept in the police station in such form as may be prescribed in this behalf by the state government. Fourth, it shall be the duty of the magistrate before whom such arrested person is produced to satisfy himself that the requirements of subsection 2 and subsection 3 have been complied with in respect of such arrested person. Section 51. Search of arrested person. First, whenever a person is arrested by a police officer under a warrant which does not provide for the taking of bail, or under a warrant which provides for the taking of bail but the person arrested cannot furnish bail, and whenever a person is arrested without warrant or by a private person under a warrant and cannot legally be admitted to bail or is unable to furnish bail, the officer making the arrest or when the arrest is made by a private person, the police officer to whom he makes over the person arrested may search such person and place in safe custody all articles other than necessary wearing apparel found upon him, and where any article is seized from the arrested person, a receipt showing the articles taken in possession by the police officer shall be given to such person. Second, whenever it is necessary to cause a female to be searched, the search shall be made by another female with strict regard to decency. Section 52. Power to seize offensive weapons. The officer or other person making any arrest under this code may take from the person arrested any offensive weapons which he has about his person, and shall deliver all weapons so taken to the court or officer before which or whom the officer or person making the arrest is required by this code to produce the person arrested. Section 53. Examination of accused by medical practitioner at the request of police officer. First, when a person is arrested on a charge of committing an offense of such a nature and alleged to have been committed under such circumstances that there are reasonable grounds for believing that an examination of his person will afford evidence as to the commission of an offense, it shall be lawful for a registered medical practitioner acting at the request of a police officer not below the rank of sub-inspector, and for any person acting in good faith in his aid and under his direction, to make such an examination for the person arrested as is reasonably necessary in order to ascertain the facts which may afford such evidence, and to use such force as is reasonably necessary for that purpose. Second, whenever the person of a female is to be examined under this section, the examination shall be made only by or under the supervision of a female registered medical practitioner. Explanation: in this section and in section 53A and 54A, examination shall include the examination of blood, blood stains, semen, swab in case of sexual offences, sputum and sweat, hair samples and fingernail clippings by the use of modern and scientific techniques, including DNA profiling and such other tests which the registered medical practitioner thinks necessary in a particular case. B. Registered medical practitioner means a medical practitioner who possesses any medical qualification as defined in Clause H of Section 2 of the Indian Medical Council Act 1956 and whose name has been entered in a state medical register. Section 53A. Examination of person accused of rape by medical practitioner. First, When a person is arrested on a charge of committing an offense of rape or an attempt to commit rape, and there are reasonable grounds for believing that an examination of his person will afford evidence as to the commission of such offense, it shall be lawful for a registered medical practitioner employed in a hospital run by the government or by a local authority, and in the absence of such a practitioner within the radius of 16 kilometers from the place where the offense has been committed, by any other registered medical practitioner acting at the request of a police officer not below the rank of sub-inspector, and for any person acting in good faith in his aid and under his direction to make such an examination of the arrested person and to use such force as is reasonably necessary for that purpose. Second, the registered medical practitioner conducting such examination shall without delay examine such person and prepare a report of his examination giving the following particulars, namely, first, the name and address of the accused and of the person by whom he was brought; second, the age of the accused; third, marks of injury, if any, on the person of the accused; fourth, the description of material taken from the person of the accused for DNA profiling; and fifth, other medical particulars in reasonable detail. Third, the report shall state precisely the reasons for each conclusion arrived at. Fourth, the exact time of commencement and completion of the examination shall also be noted in the report. Fifth, the registered medical practitioner shall, without delay, forward the report to the investigating officer, who shall forward it to the magistrate referred to in section 173 as part of the documents referred to in clause A of subsection 5 of that section. Section 54. Examination of arrested person by medical officer. First, when any person is arrested, he shall be examined by a medical officer in the service of central or state governments, and in case the medical officer is not available, by a registered medical practitioner soon after the arrest is made. Provided that where the arrest person is a female, the examination of the body shall be made only by or under the supervision of a female medical officer, and in case the female medical officer is not available, by a female registered medical practitioner. Second, the medical officer or a registered medical practitioner so examining the arrested person shall prepare the record of such examination, mentioning therein any injuries or marks of violence upon the person arrested, and the approximate time when such injuries or marks have been inflicted. Third, where an examination is made under subsection 1, a copy of the report of such examination shall be furnished by the medical officer or registered medical practitioner, as the case may be, to the arrested person or the person nominated by such arrested person. Section 54A. Identification of person arrested. Where a person is arrested on a charge of committing an offense and his identification by any other person or persons is considered necessary for the purpose of investigation of such offense, the court having jurisdiction may, on the request of the officer in charge of a police station, direct the person so arrested to subject himself to identification by any person or persons in such manner as the court may deem fit, provided that if the person identifying the person arrested is mentally or physically disabled, such process of identification shall take place under the supervision of a judicial magistrate, who shall take appropriate steps to ensure that such person identifies the person arrested using methods that person is comfortable with. Provided further that if the person identifying the person arrested is mentally or physically disabled, the identification process shall be videographed. Section 55. Procedure when police officer deputes subordinate to arrest without warrant. First, When any officer in charge of a police station or any police officer making an investigation under Chapter 12 requires any officer subordinate to him to arrest without a warrant, otherwise than in his presence, any person who may lawfully be arrested without a warrant, he shall deliver to the officer required to make the arrest an order in writing, specifying the person to be arrested and the offence or other cause for which the arrest is to be made, and the officer so required shall, before making the arrest, notify to the person to be arrested the substance of the order, and if so required by such person, shall show him the order. Second, nothing in subsection 1 shall affect the power of police officer to arrest a person under section 41. Section 55A. Health and safety of arrested person. It shall be the duty of the person having the custody of an accused to take reasonable care of the health and safety of the accused. Section 56. Person arrested to be taken before magistrate or officer in charge of police station. A police officer making an arrest without warrant shall without unnecessary delay and subject to the provisions herein contained as to bail, take or send the person arrested before a magistrate having jurisdiction in the case or before the officer in charge of a police station. Section 57. Person arrested not to be detained more than 24 hours. No police officer shall detain in custody a person arrested without warrant for a longer period than under all the circumstances of the case is reasonable, and such period shall not, in the absence of a special order of a magistrate under section 167, exceed 24 hours exclusive of the time necessary for the journey from the place of arrest to the magistrate's court. Section 58. Police to report apprehensions. Officers in charge of police stations shall report to the district magistrate, or, if he so directs, to subdivisional magistrate the cases of all persons arrested without warrant within the limits of their respective stations, whether such persons have been admitted to bail or otherwise. Section 59. Discharge of person apprehended. No person who has been arrested by a police officer shall be discharged except on his own bond or on bail or under the special order of a magistrate. Section 60. Power on escape to pursue and retake. First, if a person in lawful custody escapes or is rescued, the person from whose custody he escaped or was rescued may immediately pursue and arrest him in any place in India. Second, the provisions of section 47 shall apply to arrests under subsection 1, although the person making any such arrest is not acting under a warrant and is not a police officer having authority to arrest. Section 60A. Arrest to be made strictly according to the code. No arrest shall be made except in accordance with the provisions of this code or any other law for the timing in force providing for arrest. Friends, here our chapter 5 has been concluded. Don't forget to like, share and subscribe Jury, and please hit the bell icon to get updates on Jury. Thanks a lot.